Hey guys, Toby Mathis here, and today we're going to talk about gifting partial interest in your house to your kids, or a better way of putting it, should I add my kids to the title of my home? Now, when does this usually come up? It's usually when there's one parent left and they have children that they intend to transfer property to. And it's not uncommon. This could be investment property, it could be single family residence, but there's a bunch of issues that get triggered when you're doing this. And let me give you kind of a 10,000 foot view, and then I'll dive into specific issues. So let's go into a couple of different circumstances. Let's say that it's mom, she's survived dad, and she wants to put her son on title because she heard somewhere from an attorney that she could avoid probate by adding that child as a joint tenant. And she thinks, oh, this is a good idea. Let me add this child because they're going to get it anyway when I pass. But let's talk about what actually happens when that occurs. When she transfers that son onto the property as a joint tenant, so there's joint tenants with right of survivorship, so he receives that property when he passes. What she did was give a gift of a half interest in that home immediately, which is going to trigger certain things in filing requirements for that gift if it's greater than $17,000. So that's number one, is that there's an issue of her giving. Number two, when you gift an asset, like a capital asset like a home or a rental property or anything, you are transferring your basis to that individual. So what happens is you lose the benefit of what's called a step up in basis when we pass away. So normally, mom and dad passes, mom inherits, let's say it's a joint property state or community property state, and the basis stepped up when dad passed, and here's mom. She's got a house, let's say that at that time it was 250,000, now it's worth 350,000. And she adds son onto that property. What she just did is eliminated that step up from the 250 to the 350. In some cases, it's far, far, far more extreme. Like, depending on how long they've owned it, there might be a lot of gain. Let's say it was a $500,000 house and now it's worth $1 million. What she did is she just transferred at the basis, the $500,000 to the son, when if she had waited until passing and just put it in an estate plan, the basis would have stepped up to $1 million. What does that mean in real life? It means there would have been no tax. Son sells the house after mom passes. There'd be zero capital gains on it if it was at the if mom does not gift it to him during her lifetime. If mom gifts it during her lifetime, now son owns one half of that property, so only mom's half steps up. So again, let's use the $500,000 goes to $1 million. There'd be a $250,000 tax. Their basis would still be 300, still be 500, 250 to mom, 250 to son. Sell it for the $1 million. Mom's basis when she passes steps up to $500,000 when she passes, but son still has his basis at 250. So there'd be $250,000 capital gains on that transaction. Boom. Oops, didn't mean that. In addition, when mom transfers that property to son, again, let's say that the basis was 500,000, but she gives it to son, and let's say it's $1 million. Then what she really did is she just made a $500,000 gift to son, and that's going to be far in excess of the $17,000 a year that you can give without reporting it. You'd have to file a gift tax return on mom's return using up her lifetime exclusion. Now, the lifetime exclusion is huge right now, just under 13 million. So like she can give away, but she still has a tax reporting requirement. Now let's talk about the downsides besides the tax implications to doing this. Now son is on title of property. What about homestead exclusions? Let's say that mom lives in Florida and has an unlimited homestead exclusion. What did mom just do? Mom now does not have $1 million of protection. Mom now only has $500,000 of protection. So a creditor of mom, let's say she goes into the hospital or something like that, the house could actually become an asset that they go after. Or let's make it a little different. Mom doesn't have the liability. Son has the liability. Son has a business that defaults, or son gets behind on some liabilities and ends up going into bankruptcy. Son goes through a divorce. Fill in the blank. Son owns one half of that house as a joint tenant. And a creditor of son could now go attach a house that was 100% protected before mom did that transfer. And all of a sudden you're like, holy kashmoli, I'm subjecting myself to liabilities that otherwise I wouldn't have. Now let's talk about if mom had sold home. Mom, again, let's just use an example. Let's say that mom bought a house for $250,000 and it goes up to $500,000. We'll just use that as a simple example. There's $250,000 a gain. If mom sold that property under Section 121, she would not have to pay any tax on the capital gains if it's her primary residence that she lived in 2 of the last 5 years. When you add son, you are now giving up that 121 exclusion because in theory, you have to own it and you have to have lived in your primary residence. Son does not live in it as his primary residence. Mom lives in it as hers. So we do not meet the requirements of 121. In theory, she might be able to get half. So she's going to cost herself a good chunk of change as a result. Other things, what if mom has a mortgage on that property? Now, all of a sudden, we have due on sale clause issues because mom's okay. Even if mom inherit, like if dad was on that mortgage, we have restrictions on most mortgages. Most laws prevent calling the note due when a spouse passes. But if you transfer a child on, there's no such exclusion. You could have a due on sale clause issue on a HELOC, on a mortgage. Next thing is you have 2 owners. So mom transfers son onto property. Mom wants to sell the property. Son could say no. Worse yet, son goes through divorce and hated daughter-in-law or son-in-law. You're angry at them and they become an owner on it because it gets awarded to them in theory, this could occur. So I doubt that a judge would really want to transfer that ownership, but you may end up with other people as owners on your property that you did not intend, and you have to get their permission to sell the property. And guess what? The default is if you're 50-50, nothing happens. And that's the reality of it is a divorce, a creditor, son just has bad business sense, and somebody ends up taking it. Son predeceases you. And all of a sudden you're dealing with son's heirs. It might be your grandchildren are all of a sudden on your property. And it might be 4 grandkids or again, it might be an in-law that you didn't intend. All of those things can occur because you're trying to avoid something like a probate. Probate can be avoided easily. Probate can be avoided simply by using a living trust and transferring the property into the living trust. You could be using other vehicles as well. You could be using a land trust. You could be using LLCs in theory. What's important is that if you want all of the benefits of ownership of your residence, that you could put them at jeopardy if you do a transfer during your lifetime to somebody else. And I'm going to give you one last example, and I'll give you a real life example. So one of my clients and her siblings were gifted an interest in dad's commercial property. He owned a very nice building, and I won't say where because I don't want to let on who these folks are. But it was 4 siblings, and they inherited. They didn't inherit. They were gifted a building during their lifetime by the dad's accountant. Said, "Hey, we want to transfer this because we're worried about the estate tax when dad passes." This was back in a time when the estate tax could have been $1 million. Ended up becoming unlimited in the year that he passed. And so this was all unnecessary tax that hit, but he transferred his property to his children. He had almost no basis in the property. He had depreciated the entire building because he owned it for over 40 years. There were some improvements that were still being depreciated, but for the most part, other than there was land that was non-depreciated and some of the improvements that were not depreciated yet, everything else was fully depreciated. So these kids ended up with a multi-million-dollar building that when they sold it, when dad passed, they ended up with a massive tax hit. They had dad's basis. So they had capital gains and depreciation recapture, all of that good stuff that would have been avoided entirely had dad not transferred it to them during his lifetime. If all he had done is nothing, if all he had done is sat on his hands and not listened to his accountant, if all he had done was wait till he passed, hold on to that building, wait till you pass, the kids would have received it with 0 tax. But because they did the transfer during their lifetime, they received it at his basis, they ended up paying taxes on millions of dollars that otherwise would not have been taxable. And so I always caution people, and I get this question a lot. Hey, my parents are getting older. They're talking about, or my mom's getting older and she's really worried. She wants to add me to title. And I'm always like, whoa. Where's mom going to live? and go in with your eyes open, understand all of the issues. There's the homestead exclusion. There's homestead, the 121 exclusion on capital gains. There's tax issues on the gift. There's liability occurrences that could be triggered as a result of having a third party, and there's control of the entity or the property itself. When you have joint tenants, all of a sudden you have to get approval from other folks, and that's just a few of the considerations that you should be thinking of whenever you're thinking about adding somebody else to title on a property. If you think somebody could benefit from this information, if you know anybody who's asked this question, please share this video with them, like and subscribe.